All right, welcome everybody. If you can hear me, raise a hand. There we go. Always good to see. I'll give it 1 minute for standard realtor time. All right. We left off last week, and this should conclude this session. The residential purchase agreement, typically it goes a little bit quicker at this point. There's a few things that are important. And then next week, we'll start in on the buyer representation agreement and some other fun forms. I think where we left off was about paragraph 9, closing and possession. So box A, right, the box in A, right, or 9A, I guess is a better way to say it. Does the buyer intend or does not intend to occupy the property as buyer's primary residence? Is this important, whether or not you check the box or not? The answer is it's important, particularly to the lender, and therefore it's going to be important to the buyer. If the buyer is buying the property as their primary residence, the rate and terms on their loan are going to be much better than if they check the box that says they do not intend to occupy it as a primary residence. Now, you may be asked by clients, I would like to say I'm going to live there, right? Whether they might say, I'm not sure if I am or not, but I've told my lender I'm going to live there because I want to get that rate in those terms. Now, we are not going to be assisting people in defrauding the lender. Heaven forbid, we're not going to do that. But sometimes the buyer is going to ask, so how will they know? What's the process here? And the short answer is the lender has software and is going to be able to identify, this is what I tell to the client, they're going to know where you live now. So if you've already got a primary residence and you're not checking that box, the lender is going to ask, well, what are you doing with your other house? If you say, well, I'm going to sell it, they're going to say, oh, is it listed yet? You know, no, it's not listed yet. Or if they say, typically they say, well, I'm going to rent it out. Because usually what happens, the buyer is, doesn't want to give up that house. So if they're going to tell the lender they're going to rent it out, what the lender is usually going to ask for is a copy of a lease agreement that shows that they are in fact renting out that property. And the lender is also going to want to see evidence that that tenant has made a first month's rent, has put money and has actually paid the buyer for that. Otherwise, they probably won't believe that they're really going to be moving in. Then it goes to 9B, seller occupied or vacant property. Possession shall be delivered to buyer. Now, unless you've got a particular reason, I don't necessarily encourage that you just start checking these boxes. Basically, it says the buyer is going to get it at 6 p.m. on the day of close of escrow. Or you could say no later than so many days after the close of escrow. So why would we do that? And the answer is because the seller wants to get their money so that they can move out and go someplace else. So sometimes we just check that box and put in a limited number of days, 3 days, whatever it might be, if that in fact is the case. Or you could write in another time and even put in another date. Now, just as a warning, and this, by the way, is true for sellers and buyers, right? I would be sure to tell them that the close of escrow date is a target, but sometimes it doesn't close on time. And sometimes it's because the lender has something or the buyer has some issue or the seller has some. I'm just saying they don't always close on time. And so if your client has ordered the moving van to come to move their stuff that at 6:15 on the day that escrow is supposed to close, they could be disappointed, right? They could be disappointed. And so you want to let the buyer know that things can happen, and sometimes the closing date can be pushed off by a day or two. That's seller occupied or vacant property. Now, if the seller is going to remain in possession after close of escrow, so if it's only going to be a couple of days, we might just put that here no later than 2 days or something like that. But let's say the seller says, I need a couple of weeks, I want 30 days, that sort of thing. What we usually use is what's called the SIP form, the SIPI form. So we would click that box, and then that, as you can see, is automatically loading the seller in possession form. Now, the California Association of Realtors and most large real estate organizations that are paying attention would like you to use that form if it's less than 30 days. If it's more than 30 days, then you're going to be checking this box, and that's a full-on rental agreement. I mean, it's a full-on rental agreement. I'll do another class at another time about the issues of filling out those forms. Like, what if they're not paying rent, and how do you fill out the form, and who's going to be paying for insurance and utilities during that period of time, and is there homeowners insurance that's going to cover them while it's, because the buyer hasn't moved in, so their homeowner policy probably isn't covering them, and the seller hasn't moved out, but they don't own it anymore, so their homeowners insurance policy isn't covering them. They're saying there are issues, right? I'm just saying that's really for another class. You should know that most lenders will not allow this to go on for more than 60 days, right? Some of them have different rules, but generally 60 days is the most they're going to let you move in, unless up here in 9A, you've checked that box. And if you check the box that that the buyer does not intend to occupy the property, they don't really care anymore about whether or not you're giving them 90 days or 100 days. You're not moving in, you don't have that kind of loan. But if the buyer is getting a loan that says, this is my primary residence, because they get better rates and terms, they can't take forever to move in. It has to be done usually within 60 days. Is there a tenant in the property? If you're a listing agent and there's a tenant in the property, my suggestion is get them out. Because one of the reasons that escrow doesn't close on time is because the tenant won't move, right? And then you have to evict them, which is very difficult to do and time consuming. Also, they're not going to let you show it sometimes. They're not going to cooperate. But sometimes I sold a property last year in Willow Glen, and they didn't want the guy to move, right? They left him in there, right? Because they were going to rent it out themselves, and there he is, willing to pay rent. Why do we need to find another tenant? So if it's tenant occupied property, notice it says at least 5 days prior to close of escrow. That's so you can go in and see if the tenant, has broken stuff and that sort of thing. Notice it says here, note to seller. Oops. If you are unable to deliver property vacant in accordance with the rent control and other applicable law, you may be in breach of this agreement. You probably are in breach of this agreement. So if the seller can't get rid of the tenant and therefore the buyer can't move in, and the buyer has the moving truck, waiting outside, but they can't go in because the tenant won't leave, and now you've got to evict them, and that's going to take 28, 30 days. The seller may be responsible for storing all that stuff, putting the buyer up in a hotel, and a bunch of other things. It is always better to get the tenant out if you can get the tenant out. Sometimes, however, we want the tenant to remain in possession. If you click that box, it launches another form, the TIP form, the tenant in possession form. Again, that's another class. So then it says in E, at close of escrow, seller assigns the buyer any assignable warranty rights for items included in the sale and shall deliver to buyer copies of any such warranties. Buyer cannot and will not determine the assignability of any warranties. This would be things like the refrigerator and the washer and dryer, or the garbage disposal, or all of those sort of things. At close of escrow, unless otherwise agreed in writing, seller shall, there's that again, provide keys, passwords, codes, or other means to operate all locks, mailboxes, security systems, alarm, home automation system, internet, intranet connected devices included in the purchase price, garage door openers. Yeah, that's sometimes an issue. We ask them, in fact, they're asked on the transfer disclosure statement, how many garage door openers do you have? If the property is in a condominium or common interest, buyer may be required to pay a deposit to the homeowners association to obtain keys to access HOA facilities. That's actually fairly common. Paragraph 10 is a list of statutory disclosures. So again, it starts with those magic words, seller shall, and it says within the time period in 14A, which we're going to be coming to, delivered to buyer, if required by law, a fully completed federal lead-based paint disclosure and pamphlet. What is that law? And that law says that if the property was built before 1978, that which is when they, stopped using lead in paint, it had been phased out. You're supposed to do a lead-based paint disclosure. There's other forms, and there's a little booklet. Most of that is included in the NHD. Unless exempt, fully completed disclosures or notices by 1102 and etc. and 1103, that's the transfer disclosure statement, also known as statutory disclosures. They're not limited to a transfer disclosure statement, the TDS. This whole class has been sort of TDS, don't you think? And natural hazard disclosure or notice of knowledge of any illegal substances, notice of a special tax or assessments, a mellow ruse, right? Is there a mellow ruse? That's, if you're not familiar, is a kangaroo taking Prozac, or maybe that's not right, a male chicken that's on anyhow. A mellow ruse is a bond that cannot be paid off during escrow. Right? Can't be paid off during escrow, which means the buyer is going to have to assume that bond, usually found on the prelim. I see a lot of them that says $30 a year for, a library or something like that. Now, all of these bonds and things are usually included in the NHD report. And if the seller has actual knowledge of industrial or a military ordinance, and of course, as you know, the law requires that if there's a military ordnance location within a mile, right, of course you all knew that the seller has to make a special disclosure. By the way, whether or not the property is located within a mile of the military ordnance site, also something you'll find on a good NHD statement, even though these things are not really natural hazards. Then in 2, any statutory disclosure required by this is important, is considered fully completed if seller has answered all questions and completed and signed the seller's section, and the seller has completed and signed the seller's broker or AVIC, right? All right, so let's stop there. Let's say, see if we have a question. I can't hear the audio, so call in. Everybody else can, right? I think that's true. So everyone else can hear the audio. I don't know why it's letting me do that, but call in. Yes, everybody else can hear me, so I'm just going to keep going. 1 second, please. Too much hot air in the room. So let's say you're, and by the way, if you're a listing agent, you want to take a peek at this. Let's say that there is a question on the transfer disclosure statement or the seller property questionnaire that the buyer, or excuse me, that the seller did not answer because they didn't understand the question or they don't think the question applies. They just didn't answer it. Now, I had a situation where I was helping another agent, and the agent had listed the property and did not answer, the seller did not answer 2 questions on the seller property questionnaire, just didn't answer them. And then the buyer had made an offer non-contingent, no contingencies whatsoever, but the buyer was an engineer. And then the buyer had figured out that what it said in the MLS in terms of the lot size was a couple of 100 feet higher than what it said in the preliminary title report. And by the way, I checked, and the numbers that were in the MLS had come not by the agent typing in the number, not provided by the seller, but was automatically filled based upon public records. So Realist, I checked, had the number that was in the MLS, but then the preliminary title report had a different number. The buyer went out to the property and measured the lot. I mentioned he was an engineer, and found out that according to his measurements, the smaller amount was in fact looked to be the most accurate. So now the buyer wants to renegotiate the price a little bit because they were robbed of a couple of 100 square feet of lot size. So we said no, right? Non-contingent offer, sorry, read the statewide buyer and seller advisory. I'll do another class on disclosures. It says that it may not be accurate, may not be exact, you know, too bad. So then the agent, who was a good agent that represented the buyer, starts going through all of the forms and finds the fact that there were 2 questions in the SPQ that were not answered by the seller. Now, this says that it is not complete until the seller has answered all of the questions, all of them. So now they send us a notice to perform, asking the seller to answer the other 2 questions. Now, you understand what happens is if you modify or amend the transfer disclosure statement or the seller property questionnaire, it triggers a 3-day right of rescission. It triggers a 3-day right of rescission. So, you know, by the way, did I mention I was not the one who did this? I took over this once it started having problems. This wasn't mine from the beginning. So what do? Well, we answered the 2 questions. Then they come back and say, ha, gotcha, right? Gotcha. Because we have 3 days to rescind, lower the price, give us, they wanted like 16,000, or we're bolting. My response was, that's BS, because the answers to the 2 questions were no, right? You understand, there was nothing disclosed as a result. And as you're going to see later, there is a part of the contract that says that the buyer has to act in good faith. And so I said, if you want to fight about this, we can fight about this, but there was nothing new disclosed as a result. You're not doing this in good faith. It's obvious from your emails, all you're trying to do is extort $16,000. It's not going to work. Not going to work, right? But you understand, if you represent the buyer and there are a couple of questions not answered, let's just say maybe not all listing agents would have been as forceful as I was about, there's no way, we're not negotiating, we don't, you don't get the 3 days. I mean, I'm just saying, you want to look at that. Did the seller answer all of the TDS and the SPQ questions, right? Did they answer them? Did the listing agent provide an AVID, an agent's visual inspection disclosure? If they didn't, you still have an out, right? Even without contingencies, you still have an out because they didn't, the seller did not fulfill their obligations under the contract. What if the buyer's agent didn't fill out their agent's visual inspection disclosure? That's not an out for the buyer, right? Not an out for the buyer. You slap their hands, but it's not an out for the buyer. Nothing stated herein relieves a buyer, if any, the obligation to the buyer's agent to conduct a reasonably competent and diligent visual inspection of the accessible areas and disclose on Section 4 or an AVID material facts affecting the desirability of the property should have been revealed, or complete any sections to be completed by the buyer's broker's firm. So what that's saying is that The buyer's agent is supposed to do their own AVID and fill out their own parts of the disclosure, but it's not necessarily tied to the seller's obligation. In other words, it's not an escape hatch for the buyer if your agent didn't do what they were supposed to do. Note to buyer and seller, waiver of statutory and lead-based and lead disclosures is prohibited by law. There are some exempt transactions, like a probate transaction and a bankruptcy transaction and a vested trust transaction that are exempt, and then we would use a different form. But you can't just say, I waive the lead-based paint. It's a federal, you can't waive it. Or I waive 1103, which is the TDS. You can't just waive it. Number 4, within the time specified in paragraph 14A, we'll get to that, seller, unless exempt, shall complete and provide the buyer with the seller property questionnaire. If seller is not required a TDS or a seller property questionnaire, they're going to do an exempt seller disclosure. Right now, I talk about commercial transactions, and that language, by the way, is not in the commercial agreement. And so even though they're exempt, there's no need for the seller to fill out an exempt seller disclosure. I'll save explaining that for another time. Buyer shall, within the time specified in 14B1, we're going to be coming to that, return signed copies of the statutory lead and other disclosures to seller. Now, if you're the listing agent, what you would like them to do is to sign all of these and submit it with the offer, right? We're going to explain why that could be valuable. If you're the seller, we're going to explain why that would be valuable. In the event, paragraph 6, that the seller or seller's brokerage firm prior to the close of escrow becomes aware of adverse conditions of materially affecting the property or any material inaccuracy in disclosures, information, or representations previously provided to the buyer, seller shall promptly provide a subsequent or amended disclosure. And then it goes on to say, a subsequent or amended disclosure shall not be required for conditions and materials inaccuracies of which the buyer was otherwise aware or which are disclosed in reports provided to or obtained by buyer or ordered and paid for by buyer. So first of all, before I get to that last line, what are we talking about? Right? I had a listing in Blossom Valley, and the seller was a general contractor, which comes up as a relevant issue. And I know the agent who's representing the buyer, her name's Ramona, and I know they were doing a termite inspection that day. And my cell phone says Ramona is calling me, so I answer the phone. And I said, hi, Ramona. And Ramona says, water under the house. And I was like, oh, all right. Are you saying that your inspection uncovered that there was a leak under the house? And Ramona says, no, there is a lake under this house. Right? Apparently, frogs in a koi pond could have gone down there. And so I called the seller up and I said, they found water under your house. And he said, oh, probably under the kitchen. And I said, well, yeah, as a matter of fact, that's, pretty good. He said, yeah, the dishwasher, it leaks and runs under the house. So I pointed out to the guy that on the transfer disclosure statement, he was asked the question, are there any known leaks? To which he replied, no. Right? You understand we have an issue here, right? Because now we have to amend the transfer disclosure statement. We have to amend it, which triggers another 3 days for the buyer to cancel. They still bought the house. Now, if we didn't, let's say we had done all those reports in advance, which he, for crazy reasons, didn't do, but we had done all those reports in advance, and he didn't mark leaks under the house. But the property inspection and the termite inspection showed, hey, there are leaks under the house. Now we don't have to amend the TDS. right? You understand? Now we don't have, because we've already disclosed it, right? So an error in the TDS or SPQ that needs to be corrected can trigger a 3-day right of rescission to the buyer unless you've already disclosed whatever that is through some other means. Worried if I was going to get all that out. Number 7, if any disclosure or notice specified in 10A1 or subsequent amended disclosure or notice is delivered, here is the 3-day rule after delivery in person. 5 days if you're going to mail it to them, or by an electronic record satisfying that would mean by email. But anyhow, 3 days is usually when we give it to the buyer, we email it to them, they have 3 days. The natural hazard disclosure and other booklets. Right? This is a good thing to get in advance. By the way, if you're representing the seller, you always want to get the environmental part of the NHD report. It doesn't cost much. And the reason you want to do it, because if I represent the buyer and they tried to save like $20 and not get the environmental part of the NHD, then we would order the environmental part of the NHD and it would provide a new disclosure, right? So if you want to sell the property without having to argue in the middle about other, disclosures, get the whole thing up front. Withholding taxes, this is FIRPTA, F-I-R-P-T-A. Going through all of that is another class, right? It's another class, the FIRPTA form, but this is just saying, that it's there. Megan's Law database disclosure. This simply says, and this is repeated usually in the NHD, that there is a website that the buyer could go to see if there are any, sexual deviants in the neighborhood. And no, we're not talking about Craigslist personals, right? That's a different thing. We're talking about the Megan's Law. Now, by the way, if you do a little bit of research, like go to Google and type in real estate neighborhood reports, you're going to find that there are a lot of sources. In fact, Neighborhood Scout for a nominal fee, like $50 a year, will allow you to generate 10 reports a month, because that's maybe enough for some of you, right? In terms of the number of buyers you're working with, 10 a month. And it gives more information. It includes everything that's in the Megan's Law database, but it includes more, right? If buyer wants further information, broker recommends that buyer obtain information from this website as during their inspection. Contingency, brokers do not have expertise in this area, right? And so if the buyer is curious about what's going on in the neighborhood, there's crimereports.com. There are a lot of there's Google, right? Just ask. If there's underground gas, LUST, liquid underground storage tanks, right? You thought I was going someplace else with that. Then that's also a notice that you're supposed to give. And most of there's a website where the buyer could check if there's underground storage tanks and things like that. Condominiums, common interest developments. Seller has, it says 7 days. Now, if you're the listing agent and you're doing it right, you've gotten a copy of all these things in advance, right? Because the goal, if you're the listing agent, is to give the buyer all of this before the buyer makes an offer. It'll be a lot cleaner that way. But the seller has 7 days after exceptions to disclose to buyer if the property is in a condominium, which you can tell, by the way, a lot quicker than 7 days. And there are questions on the TDS and SPQ that ask that. I think the seller knows if they're paying HOA fees. I just think so. If the property is a condominium or located in a planned development, what's the difference between a planned development and a condominium or other common interest? So there's a condo, which is generally a one-level, thing. Then there is a planned unit development, which is called, which stands for PUD, P-U-D. We have another name for that in the industry. Does anybody know what the other name is for a planned unit development? Begins with a T and ends with townhouse. Townhouse? A townhouse, right? A townhouse is a planned unit development. And then there are planned development projects. And that's where you have single family homes, but there's still a homeowner association. There's still a homeowner association because they have a pool or a tennis, Santa Teresa swimming racket club, you know, things like that. Anyhow, what that means is, is there a homeowner association? And again, the seller has 3 days after acceptance to request the forms from the HOA. You should do this a lot sooner. You see, if I'm representing the seller, what I would like is for the buyer to make a non-contingent offer. If we don't have homeowner association documents, he can't do that. If we don't have inspections, he can't do that, right? If we don't have the TDS filled out and all those things, we really can't do that. I Googled real estate neighborhood report, but didn't find that website. Maybe it's called Neighborhood Scout. When I Google it, I find the website, right? Neighborhood Scout. I don't know. I've done this recently for another agent, but Neighborhood Scout, there's a lot of them. I'm not going to do that right now. All right. So 3 days out, copies of any such documents required, disclosure of pending litigation, statements concerning the location, storage, copies of 12 months of the HOA minutes, names of contact information, pet. So what does the buyer really care about, right? Because what you end up with is, you know, sometimes these are 500 pages long. What does the buyer really care about that's in the HOA docs? Pet restrictions, right? They have 6 German Shepherds, probably not going to be allowed. Pet restrictions. Number 2, rental restrictions. Let's say they choose to rent it out, the unit that they're buying, Airbnb, something like that in the future. Many HOAs have restrictions on that, right? Buyers want to know. Number 3, whether or not they could operate a business, Mary Kay business or something else out of the condo. Many of them have restrictions on that. What else? So what I've always found was I would like to read there are meeting minutes of the HOA. You're going to find that most of the interesting stuff is in the bylaws and the rules. Can you clarify the number of days for right of rescission when the seller makes a new disclosure? 3 days or so technically clarify that. All right. So technically speaking, if you give it to the buyer, it's considered 3 days from the time they've received it. Unless you give the TDS and the SBQ to the buyer prior to making the offer, in which case they get no days. Now, the by mail has been interpreted to mean not just putting it in an envelope and mailing it, but generally includes email, simply because people don't always read their email right away, right? That's according to the California Association of Realtors. So technically there's 5 days if you email it. Now there's a delivery notice addendum, DNA form, which I may go through. I'm going to probably do a class where I go through all these little miscellaneous forms, which if you're the listing agent, you can include in the disclosure packet that tightens that up. And basically it says emailing it to the buyer's agent constitutes delivery to the buyer, right? But the mailing is 5 days, and that includes email. 3 days if the delivery is made in person. How about if you're the seller, you want to do this, representing the seller, you want to do all this in advance. You want to do all this in advance. Smoking, do all the seller shall itemize and deliver all CI disclosures and possession. Buyer's approval of the CI disclosures, that's common interest development, is a contingency of this agreement, as specified in paragraph 14B3, which we're going to get to. So if I'm an agent representing the buyer, I want to look at the HOA docs, rent restrictions, if they smoke, smoking restrictions, pets, pet restrictions. But I'm also going to look at the rules. Some of that's found in the rules, in the bylaws. But I'm also going to look at the homeowner association documents. I'm going to, and what I'm, excuse me, the homeowner association meeting minutes. Right? I don't know. I have to admit, I don't read the whole, every single page, but I go through the meeting minutes. And I remember I sold a townhouse up in Almaden, and I'm looking through the HOA meeting minutes, and they start talking about wild pigs, right? Apparently there's wild pigs running around where this unit is. And I'm reading in the next meeting, there's more, talking about wild pigs. I'm reading, they formed at the HOA a wild pig committee. And then eventually I'm reading, they hired a professional pig trapper to come up and to, catch all the wild pigs. I did not realize that this was even a career choice. I might be doing that instead. And the guy caught like 11 wild pigs one weekend. You understand what I'm saying? We're not talking about a pig here and a pig there, right? We're talking pig everywhere, right? There's all these pigs running around. And so I'm pointing this out to the buyer. And she's like, oh my God. And she had a teenage son, and I promised her that, they had a big barbecue pit out there, that I would get the teenage son a crossbow, which by the way is not legal. And she decided she didn't want to buy the property because of the wild pigs. And so if you read the meeting minutes of the homeowner association, sometimes that's where they're fighting about stuff. They give you copies of the newsletter, right? And in the newsletter is when they talk about, hey, everybody, be careful. We've been having burglaries and things like that. Just saying, right? So what some agents do, and I, oftentimes represent sellers, is the agent gives the stack to the buyer, but the buyer doesn't really read it. The agent doesn't really read it. And then they move in and they find out that there's wild pigs running around everywhere. And then the agent calls me up saying, you guys didn't disclose this. You should have told us about the wild pig infestation. And my reaction is, we did. We did. You just didn't read the disclosures, but it was all there. And by the way, my job as a listing agent is not to go through the HOA documents for you if you're the buyer's agent and mark stuff for you and point at it. That's not my job, right? You're getting paid a commission. That's your job, right, to go through. And by the way, I got to the point where if I'm representing buyers and I see things like the wild pigs or something, I'll actually make a little mark next to it, and I'll have the buyer initial that they saw that section in the HOA docs, right? I'm just saying. And by the way, I've actually heard some brokers say, well, it's not our responsibility to read them. We just give them to the buyer. They're supposed to read them. My feeling is if you do that too much, you're going to meet lawyers, right? You're going to meet lawyers. Condition of the property. How many times have you seen a listing agent put in the private remarks, properties will be sold as is? Yeah, this is just a waste of time. What does it say under condition of the property? It says the property is being sold as is, in its present physical condition as of the date of acceptance. What does as is mean? And the answer is, it means the buyer is not obligated to fix stuff. That's what it means. A long time ago, and actually in the PRDS contract, which is the Peninsula Regional Data Service contract used in some places in San Mateo County, that default setting contract used to be, it may have been changed recently, was what we used to call the seller warranties. And the seller warranties were things like a 1-year leak-free warranty on the roof and Section 1 termite clearance and no plumbing leaks and things like that. So what this is saying is that the contract does not have any seller warranties. The seller is not obligated to fix stuff. However, the buyer is allowed to investigate. So if the seller says as is and the contract says as is, can you still ask for the seller to fix stuff? And the answer is sure, why not? Why not, right? We'll talk about that in another time. Seller shall, within the time period specified in 14A, we're coming to that. Notice this is in all caps. Disclose known material facts and defects affecting the property, including known insurance claims within the last 5 years, and make any other disclosures required by law. That's often missed. There is a report. It's called a clue report. Have you got a clue? A CLUE report. And if I'm representing the seller and I ask the seller, and by the way, there's questions about this in the SBQ and the TDS, but what a clue report, a comprehensive loss underwriting evaluation, but you guys all knew that. What that is, it's basically like getting a prelim or a property inspection based upon your insurance claims. And you need to know that if this seller has been filing insurance claims in the last 5 years, there's a good chance that your buyer will not be able to get homeowners insurance, may not. And if the buyer can't get the homeowners insurance, they're not going to get a loan. Not going to get a loan. I mean, somebody says my voice has stopped. That may be wishful thinking. Has my voice really stopped? Is my voice really? No, I didn't think so. Many of you are wishing it would, but no, not that easy. Then it says the buyer has the right to conduct buyer's investigations of the property. We'll get to that. Buyer is advised to conduct buyer investigations of the property. Boy, are they ever. Now, paragraph 12 is what I think is the, one of the best contingencies. Buyer's, oops, let me do this right. Buyer's acceptance of the condition of the property and any other matter affecting the property is a contingency of this agreement. How broad is that? Buyer's acceptance of the condition of the property and any other matter affecting the property is a contingency of this agreement. As specified in 14B, we're going to get there. Buyer shall have the right at buyer's expense, unless otherwise agreed, to conduct inspections, investigation, tests, surveys, other studies. I've had people do radon gas. I've had people do asbestos. I've had I've had people do they have brought ghost hunters in. I've had just all sorts. If the buyer says, well, I have a shaman that I want to come in and see if there's great, right? Do it, right? Yeah, the asbestos one was kind of trippy because, it's like an old Geiger counter kind of a thing, and it starts making noise, when there's asbestos. And so they're like, oh my God, there's asbestos. And by the way, there's, it's more prevalent than you think. And so the guy goes out he said, this isn't bad. And he walks out on the sidewalk, the meter shoots up. He walks out on the road, it shoots up, way up, right? There's asbestos. But basically this says is that the buyer can have just about any inspection they want, as long as they're willing to pay for it and they don't break anything doing it or get the seller in trouble because they've done stuff without permits and things like that. In other words, you can't call the city up and say, I want you to send out one of your inspectors because I don't think this was done with permits. It says here, you're not going to do that. Right? And I don't know if I should go through the whole thing, but any inspection of wood destroying pests and organisms may not include water tests, shower pans. There's just a whole bunch of stuff here. There's just a whole bunch. Basically, it says that you can do just about anything you want, but without seller's prior written consent, buyer shall neither make nor cause to be made invasive or destructive buyer investigations. And government building zoning inspector employees, unless required by law. Seller shall make the property available for buyer investigations. Buyer has to give a seller a copy of all of the inspections. That's what it says. Buyer's investigations and either remove or cancel this agreement and give seller at no cost complete copies of all such investigation reports obtained by buyer, which obligation shall survive the termination of this agreement. So if you have your own inspector come out and the inspector finds something and you say, we're terminating the agreement because we found something wrong with the property, you have to give the seller a copy of that report. The seller has to keep the lights on, the gas on. The buyer is going to indemnify the seller against, breakage and let's say the termite guy, hurts himself doing the inspection, the pool inspector falls and hurts themselves. This is saying that this is the buyer's problem, not the seller's problem. That's pretty much. By the way, one of the things, when we used to do this and in front of people with pieces of paper, one of the things that I learned to do was to go through the contract upside down, because they're looking at it across the table. And if I keep turning around, it's kind of difficult. Now, most of the time when I'm doing this, I'm going through it on like this, right? Where we can go through it together and they're watching and they can ask questions. But sometimes you're going to have a buyer that really wants you to answer questions. One of the agents that I was coaching elsewhere, his buyers, both of them had PhDs and engineers, and what they had done is we sent them all the disclosures and stuff, and they stayed up like one night going through the contract and all of the disclosures, doing screenshots, putting them in like a Google Doc and typing in questions. It was like 60 pages of questions, and then they sent it to the buyer's agent saying, we'd like to meet and talk about this. He kind of freaked out, right? And I'm looking at them, and they were softball questions, but then I've read the contract and done this before. So we had them come in, we put it on the screen, their list of questions. I went through all of the questions. Sometimes somebody's going to ask you to explain all this stuff, right? Now, if you're part of my group, I'll help you. If not, you better practice. Title investing. Essentially, when we're talking about title, we're talking about the prelim. We're talking about the prelim, right? The buyer shall be provided a current preliminary title report. The preliminary report is only an offer. They won't guarantee that they're going to give you insurance. Look at this here. Where am I going to? Buyer's review of the preliminary report and any other matters which may affect title. Any other matters which may affect title are a contingency of this agreement. Remember, I told you go through and find everywhere where it says contingency. Now, you should look at the preliminary title report. One of the agents that I coach, the property had been purchased originally like 20 years ago through, was it the Santa Clara County Housing Trust? I think that was it. Or the Silicon Valley Housing Trust. And in the prelim, there was a little hyperlink to the deed. And the agent didn't click on the hyperlink and look at the deed. And I told her later, I sometimes do that if I'm bored, but normally don't do it. Well, it actually matters whether or not it's the Silicon Valley Housing Trust or the Santa Clara County Housing Trust that lent them the money to buy it in the first place. Because one of them says that after a certain period of years, and this was like, this house had been owned like 30 years, I think it was after like 20 years or something like that, the owner can sell the property and do whatever they want. But it wasn't that housing trust, it was the other housing trust. And the other housing trust had a rule that says you cannot sell the property ever except back to the housing trust. Except back to the housing trust. So the buyer we're in contract to buy this house, and it's now, at escrow, and that seller cannot execute a deed on this property because, and if you clicked on the link, the hyperlink in the prelim, it would take you to the deed and it said it on the deed. I'm just saying. One of the classes I may throw in is how do you read a prelim, right? And I may get a friendly title company to help with that. The company providing the prelim shall, prior to issuing the report, conduct a search of the day. Yeah, they're going to look. Seller shall, within 7 days, give escrow holder a completed statement of information. You should have done this before, right? The statement of information is what we use to really start the escrow process. Title is taken in its present condition, subject to all encumbrances, easements, covenants, conditions, restrictions, rights, and other matters, whether of record or not, as of the date of acceptance, except monetary liens which the seller is obligated to pay. Those have to be paid off in escrow, or unless the buyer is assuming them, or those that the seller has agreed to remove in writing. Seller has a duty to disclose to buyer all matters known to the seller affecting the title, whether on record or not. What would that be? What could that be? Right? Now, let's say the seller has had work done recently by contractors, and the seller hasn't paid them yet, and maybe doesn't intend to pay them at all. That could create a mechanics lien. And the mechanics lien, as I'm sure all of you know, is not effective the day the mechanics lien is recorded, but the day the work began. And that would be a matter that would affect title. Let's say there's something called a prescriptive easement, which is where the neighbors are driving back and forth and back and forth and back and forth, and the owner knows that. If they've been doing that for 5 years or longer, they may have a right to do it. Those are not matters of record, right? You can't actually see that. If the seller knows about those things, they're required to tell the buyer, or they could be sued. Buyer is going to get a deed conveying the title, or a stock cooperative. That's a whole nother class. I'm not going to do a whole class on stock cooperatives or tenancies in common. There are some stock cooperatives in Santa Clara, however, and elsewhere. The manner of taking title can have significant legal and tax consequences, right? So you don't want to give them advice. They're going to get a CLTA Alta policy. You ought to, know a title rep and maybe go to one of their classes. Time periods and removal of contingencies. So this is where it says removal of the contingencies. Any removal of contingencies or cancellation by either the buyer or the seller must be exercised in good faith and in writing, right? In good faith. So I sell a house in Blossom Valley, and after we're in escrow, there's an inspection contingency, but no loan contingency. And at some point we got into a disagreement, I guess, between the buyer and the seller. And so the buyer's agent wanted to cancel, right? And based upon their inspection contingency. So I get this thing with a cancellation notice, and it says that the buyer is canceling because of 2 reasons. One, that the MLS said a 3-car garage and it's really only 2.5. And 2, the buyer has determined that there's not enough space in the backyard to put in a kidney-shaped pool, right? Those were the 2 reasons they gave me. And I said, we're not canceling, we're not giving you your deposit back. And the reason is because those things are things that the buyer saw when the buyer inspected the property. So in terms of what constitutes good faith, your inspection contingency is really based upon you inspecting the property as the buyer and finding something that you did not already know was wrong. That's why we want to give the buyer a copy of the termite report, all of those things. And that's why agents want to see the buyer's signature initial on the first page of all the inspections and reports. Because if you try to back out after that, based upon something that was in those reports, there's an argument to be made that you are not acting in good faith. And by the way, I told them, we're not giving you your deposit back, right? Eventually they hired a lawyer, and the lawyer called me. And I said, we're not giving you the deposit back until we sell it to somebody else. And the lawyer said, we're going to hold up the escrow. You won't be able to sell it to anybody else unless you give us the deposit back. And I'm the listing agent in this, and I said, we'll open escrow someplace else. How about that? We'll just open it up at another escrow company, they'll be happy to do it, and we'll sell it to them. So what I'm going with this is, if you are representing the buyer, and by the way, if you're on my team, talk to me before you do this, but I'm just saying, if you're representing the buyer and the buyer is trying to use an inspection contingency to cancel, be a little more creative, right? For example, remember the neighborhood reports and Megan's Law and crime reports? You could go do research and say, oh my gosh, there's crime in the neighborhood. We didn't realize that, we want out. Or simply to say, we drove by the property at night and it sounds, bad, and all that other kind of stuff. Now, the question I'm being asked, can you really keep the deposit? Well, do they really want to fight over it, right? I told them, when we sell it to somebody else for an equal or greater amount, we'll give you the deposit back. But you understand, if you're representing the buyer, is it really in good faith for you to be given all these disclosures, not read them, not look at them, and then later say, well, I'm going to back out because of something that I didn't read or look at? Or it was something that was really obvious, like, the garage, and then say, oh, well, I'm going to cancel because now I don't like the garage. There's an argument that that's not in good faith. And so I'm being asked, why didn't they come up with another reason? They weren't very creative, right? They just weren't very creative. Come up with another reason. Something like school rankings, right? Something that was not included in the disclosure package. If you've got an inspection contingency and you want to cancel, don't do it based upon something that the buyer knew or should have known when they made the offer, because that's probably not acting in good faith. But, the lawyer, we eventually, sold it to somebody else, and I gave him the deposit back. So seller has 7 days in order to give all these inspections and reports. That's why you want to do them up front. Buyer has 17 days after acceptance to complete all investigation, review the disclosures, and do all that stuff. That, by the way, is sort of assuming that they hadn't been given copies of all this in advance, right? There's an argument that if you got it all in advance, for example, the transfer disclosure law, the civil code says that 3 or 5 day right of rescission is only if you've been given copies of those documents after escrow has opened, not if you've been given copies of them before escrow opens, right? I'm just saying. So let's say, I'm going to hurry this up a little bit. Let's say the buyer is making an offer non-contingent, no inspection contingency. Can the buyer still do inspections? No inspection contingency. Can the buyer still do inspections? And the answer is yes. Where does it say that? 14B5, access to the property. Buyer shall have access to the property to conduct inspections and investigations for 17 days. Agents never change this, I say, hardly ever. And this is true whether or not the buyer's investigation contingency has been waived or removed, whether or not. So I've had 8 listing agents say, well, you don't have an inspection contingency, so we're not going to let you inspect it. No, you can't do that, right? We can still inspect it, even if we don't have it. The fact that the contract isn't contingent on what we find out in the inspection doesn't mean that we don't have the right to inspect it. We have the right to inspect it. Now, if you're going to not have an inspection contingency, don't type 0 here. Don't type 0 there. What you do is you click on the removal of contingencies, which loads another form, and we'll talk about how to fill that out. There are 3 parts to that form, an A, a B, and a C. A allows you to remove individual contingencies, B allows you to remove all contingencies except, and C says remove all contingencies. Don't put in 0 days, right? Just don't do that. You remove them. If you don't have them, you don't put in 0 days. Seller's right to cancel. So I'm going to summarize this a little bit, but if the buyer is not removing their contingencies on time, what the seller is required to do is to give the buyer what's called a notice to perform, right? A notice to buyer to perform, an NBP. And then that gives the buyer 2 days in order to perform. I'm going to do a class just on contingencies and notices to perform and how does all of that work. If this goes down here. So if the buyer does not remove their contingencies within a contingency period, it doesn't automatically cancel the contract, nor does it mean the contingencies have been waived by the buyer. The buyer just hasn't removed them. So what you would do is you would give a notice to the buyer to perform, which is to remove their contingencies. Notice they have 2 days to do that. And we'll talk about what does days mean. If the buyer removes the contingency in writing, it means the buyer does not have a legal right to get out of the contract based upon that contingency. Think of it like escape hatches in a boat, right? Every contingency removed, you're nailing shut one of the escape hatches until there are no more. Let's say the buyer isn't able to close on time because the lender is dragging their feet or whatever. Now there is a notice to close escrow, or excuse me, a demand to close escrow, a DCE, and the buyer would then have 3 days, right? And when I get into the contingencies and all of that, which is another class, then, you know, I'll explain a little more about what happens to the deposit. Well, if the buyer has removed their contingencies legitimately in good faith within the right time period, the buyer gets their deposit back. If not, then we could fight. If a part, notice it says at the end, a party may be subjected to a civil penalty of $1,000 for refusing to sign a cancellation instructions if no good faith dispute exists. I'm just saying. Final verification of condition. If it's okay with you guys, I may go about 5 minutes over, but you know, I'm just saying. Agents always often call me up and they say, I'm looking for the walkthrough form. I cannot find it. And I've been searching all through Zipforms. I can't find walkthrough. I can't find the walkthrough form. Well, it's called a verification of property. It's a VP form. It's not called, we call it a walkthrough. That's not the name of the form. This is not a contingency of the sale, but it's simply confirming that they haven't trashed the place. What if they have? What can you do? Well, maybe I'll go over that when I go through the forms, but essentially hold back money in escrow or not close. Repairs. Generally, lenders don't like to see you fixing stuff during escrow. I'm just saying that. And maybe if you're doing repairs, I'm just saying the lender probably doesn't want you to be contractually repairing the property during escrow, because then it brings up the question whether or not the property is worth as much as the appraiser thinks it is, because you're having to fix stuff. I'm just saying, right? I'm not going to go, there's forms about repairs. When I go through the individual forms, I'll do that. Property taxes, this is just a disclosure. Broker's compensation, this doesn't say anything about how much you're being paid. Representative capacity means if the buyer is an LLC, the seller is in a trust, it's a form that basically says I'm signing on behalf of somebody else. Joint escrow instructions, this is just a big boilerplate section that says that this contract is going to be turned over to escrow, and escrow is going to write their escrow instructions based upon the terms of the contract. I'm summarizing. And you can amend that later by escrow instructions signed by everybody. What happens if there is a breach? This is called liquidated damages. And with liquidated damage, by the way, do you have to have a deposit in order to have a valid purchase contract? And the answer is no. No. What happens if you don't have a deposit? It means that if the buyer breaches the contract, the seller would have to sue the buyer in order to get paid the damages, right? Who wins when sellers sue buyers for monetary damages? And the answer is lawyers. Lawyers win, right? That's who wins. So what this is saying, that if this is a and by the way, if this is a 1 to 4 unit residential property owner occupied, The California Civil Code says that the maximum amount that the seller can keep is liquidated damages. That means the buyer's forfeiture of the deposit is 3% of the purchase price. You could give 5%, 7% as a deposit, but they can only keep 3%. I have people asking me, where did the 3% come from? That's where it came from. Mediation and arbitration. I explain this to clients. Mediation is like marriage counseling. You don't have to do what the marriage counselor suggests. Arbitration is divorce court. You have to do what it says. And the difference, by the way, in most counties, any dispute involving a real estate contract would go to arbitration. Anyhow, what this paragraph says, summarizing, is that it's binding arbitration, which means you cannot appeal it. Can the seller unilaterally send a cancellation letter without first sending a notice to perform? Not under the terms of this contract. No. The contract says you can't just cancel without doing the notice to perform first. That's what the contract says. So you understand the difference between this arbitration and where it would normally go is that this arbitration is binding. Notice there's an exclusion, any matter within the jurisdiction of probate or small claims court or bankruptcy, right? But that means that the buyer could still sue the seller in small claims court. That goes up to $10,000. Selection of server for MLS, attorney's fees, assignments, time is of the essence, a bunch of definitions. I'll go over them in another class. Here's the last important paragraph, paragraph 31. At this place, you should write in your name. Now, by that, I don't mean the words your name. I mean your name. Because if you don't do that, it says once you've made the offer is communicated back to the buyer. It has to say either personally received by buyer, don't know when that's going to happen, or by your name, who is authorized to receive it. Now, when I go over the contingencies and I'm going to talk about the DNA, the delivery notice addendum, because agents, play around with this. And then my suggestion is before you write an offer, you call the listing agent up. And I actually, if you're in my group, I have a list of questions to ask. You call the listing agent up and you ask them, do you have any offers? Can you tell me what they are? Are you getting a lot of, and what you might ask is, how soon can you present the offers? And if the listing agent says, well, the seller's around, if I had an offer today, I could get it to them tonight. You don't want to give them 3 days, right? The default setting is the seller gets 3 days to think about your offer. If you were selling your house, how long would it take you to decide if the contract was something you liked? Here's the number, 1.2 million. How long would it take you to decide if that was a good price or not? 3 days? It wouldn't take 3 hours. How about 3 minutes, right? 1.2 million, no, right? That's, or yeah, right? This doesn't take very long. And if you give the listing agent too much time, they can shop your offer. I talk about this in the listing agreement. It gives me, if I'm the listing agent, the right to mention your offer and how much it was to other agents. So if I get an offer for you for 1.2 million and you've given me a lot of time and an agent calls me up and they say, well, do you have any offers? Yeah. Can you give me an idea of how, what you're 1.2? Oh, all right, cool, right? And I say, yeah, you're gonna have to beat that. Right, and then I've done this where I did this 5 or 6 in a row. We had eventually had 10 offers. The guy who made the first offer ended up, his client bought it, but it was $100,000 more by the time it was done, because every time I'd get an offer, I would tell the other agents, and then they would build higher, and it just kept going up and up and up and up and up. You don't want to give the listing agent and the seller too much time to think about it, unless there's a good reason. They're out of the country. But even then, my seller was in Singapore. They had internet there, it didn't take, as soon as he got up the next morning, he signed it and sent it back to me. How long do they really need to decide if they like your offer or not and to agree to it, right? I don't know. If the buyers are buying because they're part of an LLC or a trust, you click that. Acceptance, this is something that we would do if we represent the seller. If there's a counter offer, you check that box, right? And you put in the date, right? I'm not going to really go to that. You cannot modify the broker's compensation in this contract. Agents always want to do it, but you can't. If you don't like what it says in the MLS, you got to argue with the listing agent. There is a CBC form, which is the Cooperating Brokers Compensation Agreement, which you ought to send to them. It's mentioned here. And I would go over, and if you haven't read this, read it. The Buyer's Inspection Advisory. You ought to read it, right? And you ought to go through this with your buyer. You really ought to inspect all of these things. You're making maybe the biggest investment you've ever made in your life. This is the most valuable asset you may ever own. You ought to go through the process of getting an inspection. All right. So the rest of this, I don't really spend time on the privacy thing. If you want to read that, you can. That's all I got for today. Next week, I'm going to go through buyer representation agreements and how they work and how to fill them out and how you can protect yourself for your commission and things like that if you do that. Sorry that, I hope that didn't go too fast, but I recorded it, and for a nominal fee, I'll let you have a copy. All right. Thank you. I appreciate your coming. Stay dry and safe out there. Bye, everybody. And by the way, if you're interested in having real help with your transactions from somebody like me, and you're interested in my coaching program, my team, or any of that sort of stuff, reach out to me. I'd like to talk to you. Bye now.